Well done for surviving so far. So we're into our last session of the afternoon. And so this afternoon, Alex Sarch and Ryan Abbott will be talking about AI and legal issues. So Ryan, over to you.
Yeah, thanks. So I'm Alex, that's Ryan. I'm going to talk for half an hour in sort of general terms about legal accountability issues that arise in connection with AI. So criminal law, tort law, what happens when people get injured by AI systems or are financially harmed by AI systems. That's what I'm going to talk about. Ryan is going to talk about I think, a different side of this thing. He's going to talk about sort of AI-generated inventions and AI-generated content, so patents and copyright. AI is revolutionizing that area of law and business, and he's going to take you through that side of things. So a little divide and conquer from us. So you'll notice we have different PowerPoint styles. I will be text heavy. Ryan will be text free. So regardless of your preferences, you'll get one of each. I should also say by way of preface that I'm only focused on domestic issues, domestic law. So I understand Alex Leveringhouse, who talked to you earlier about killer robots, he was talking about law of war. I know nothing about that. I'm not going to talk about killer robots used by the military, although I will talk about some automated weapon systems and whether or not the companies manufacturing them, if they're used in a domestic context, might have to pay compensation in the event that they accidentally injure someone. So I will touch on that, but Alex is the international law of war person around here. Cool, so, all right, here's what to expect. I'm going to briefly just sort of give you an overview, introduce the topic here. I'm going to then extract 3 themes that we'll sort of see playing out again and again when the law as it exists now meets artificial intelligence systems. So 3 kind of recurring themes. Then we're going to look at 4 case studies. We're going to talk about 4 paradigm cases where the law is being challenged by artificial intelligence. And then I'll just wrap up and talk about some conclusions and offer some possible solutions for where we might be. OK, so what's the basic issue? How big a deal is the introduction of artificial intelligence from a legal perspective? If you read the news, you'll see 2 competing views. You'll have, first of all, the alarmists who say that artificial intelligence is changing everything. It's going to require a massive revolution. The law as we know it is going to be overturned and anarchy will reign. You see some of those guys. I think Luciano Floridi has some, as was mentioned in the past. He has some inclinations in that direction. He's thinking about the big changes. But then you have the other people, the conservatively minded people who say, everything will be just fine, don't worry. The legal system can adapt. It's dealt with technological change before. And it can be extended in minimal ways. And everything will be fine. Don't worry, nothing to see here. So those are the 2 extremes. And you see a bunch of lawyers and policymakers in the latter camp. My view is that the reality is probably going to be somewhere in the middle. We will have to see some change and flexibility within the law. But existing legal principles will get us pretty far. I don't think we'll have to reinvent the law in order to deal with artificial intelligence. So that's the kind of general picture that I'm going to sketch for you, a kind of compromise position, which I always try to do in my talks in order to present myself as the reasonable person in between the 2 extremes. All right, cool. So the main challenge that the law proposes, or that the law encounters here, is that you need some kind of legal accountability for AI systems, or else the public is going to have difficulty sort of seeing AI systems as trustworthy, right? So if there's no accountability or insufficient accountability, if AI systems can cause harm and no one is held to account, that seems to undermine the public perception of trust in AI systems generally. So there's a threat here of a possible techlash in the event that there's not sufficient accountability, right? Or sufficient responsibility by companies and owners and operators. So we want to be able to realize the benefits of AI systems. They're valuable, they're creating efficiencies, but we need some legal principles to impose responsibility. Otherwise, there's a trust deficit. So what does that look like? The question I'm going to talk about in my presentation here is sort of what accountability for AI-generated harms, what shape they'll take. And I'm going to look at the question of how far does the existing law generally get us. I'm going to focus on Anglo-American systems like England and the US. And I'm going to look at whether or not there are any gaps, where the challenges or where the shortfalls in accountability for AI harms. I will focus on physical harms and financial harms. Those are two of the most important. There are other kinds. I'm not going to talk about discrimination. That's its own sort of interesting, sort of algorithmic bias, super interesting, but it's governed by other legal principles. Just don't have time for everything. But think of this as a taster. I'm going to not do 6 paradigm cases, but 4, because this is a mistake in the slide. But we'll get to the 4 in a second. OK, so that's kind of what's coming up here. There are 3 themes that I want to draw your attention to, 3 kind of big takeaway messages. The first of all is that AI does pose something of a challenge for imposing liability because of what are called legal causation requirements. So generally, this is a broad generalization about law, and there are some exceptions. But as a rule, you're only going to be able to impose liability, to make somebody pay compensation, as it were, in cases where you can trace the harm back to some responsible actor. Artificial intelligence creates problems here because it operates autonomously. And so it's difficult to say that, for example, the company that deployed the AI system that proved to be harmful, right? It's difficult to trace a chain of causation from what the programmers did a long time ago through the autonomous system that caused the harm, and then to the ultimate injury. So there's going to be difficulty in tracing a chain of causation that the law generally requires in order to impose accountability. So we'll see this play out in the case studies that we get to. That's one of the big challenges that I think AI generates for existing legal principles. Not all hope is lost. The law does have some tools to deal with it, and we'll talk about what some of those are. OK, here's another legal challenge that I think AI poses. So it has to do with distinguishing, as you can see from the red phrase there, it has to do with distinguishing AI-caused harms that are really due to a defect, a design flaw, or a kind of malfunction on the one hand. How do you separate that from a non-malfunctioning system that just gets it wrong, sort of in one of the few cases where there's a pure accident, where there's no responsibility or no liability? How do you separate the defective systems from those that are operating properly, but there's just an accident? How do you separate those two? That turns out to be especially difficult for AI because of the black box nature of machine learning systems, right? So the explainability challenge, I'm sure many of the speakers today have talked to you guys about this, so I'm not going to go into those details. But generally, it's quite difficult to figure out, to sort of look under the hood and figure out what was the algorithm really paying attention to and affording weight to, and what wasn't it. As a result, it's difficult to explain the decision-making process that led to the behavior. And that means, as we're going to see, difficult to distinguish defective AI systems from those that are operating properly, and there was just an accident where you would think no liability is appropriate. How do you separate those two? That's a further challenge. OK, the last thing I want to say, third theme. Sometimes if you read the popular press, you'll see people propose AI personhood as kind of the broad cure-all for all the legal accountability gaps that you might encounter, the difficulties in imposing liability. People will say, oh, there's an easy fix. We recognize artificial corporate persons. The law treats companies as persons. Let's just do the same thing for an algorithm. Let's just sort of invent this new category of e-personhood, which has been proposed in the EU context. Ryan might say more about that. That's not a cure-all. That's not an easy solution to these problems, at least so I'm going to argue. There are a couple different challenges. One is conceptual. What would you actually recognize? What would you give personhood to? Is it the software? Is it the code? Is it this particular computer? Is it this particular company? What if it's a distributed network, et cetera? So there's a conceptual question there. But more importantly, there's a practical question. It's easy to understand if you give a company personhood, right? There's a company, it owns assets, right? It's capitalized, it can pay compensation, it can incur debts. You'd have to enable all of that with respect to AI personhood as well. So you'd have to make sure that the algorithm or the computer or something is capitalized, can own assets, can incur legal liabilities. That's a whole can of worms. It's extremely difficult, practically speaking, to do that. And so I think for practical reasons like that, AI personhood is not a cure-all. It's not a sort of universal fix to the liability gaps that we're going to see. Finally, there's also a policy problem. So if you give AI, if you recognize AI personhood, personhood carries with it generally some rights, or at least we think so when it comes to human actors. It's not necessary that if you have an AI person, or if you recognize AI personhood, it'll get all the rights that humans get, but it will probably get some of them, and there's a question about which ones. And so you're likely to see, if you recognize AI personhood, you're likely to see an expansion of the AI person's rights. And that can come at the cost of valuable human activities. It can burden human sort of protections and human rights and general freedoms. I think you see something like this right now in the US with respect to corporate personhood. You guys remember the Citizens United case, which the slogan against Citizens United is that corporations are not people and money is not speech. Well, there's a line of cases in the US that suggest that corporations, if they're real persons, they get certain rights, like free speech rights, or like a right to protected sphere of religious activity. Does that make sense for a corporate entity? Courts seem to be taking it seriously, and that, you might think, has some interesting and radical implications. The same thing could happen with respect to AI personhood. If you recognize AI as having real personhood for legal purposes, it'll get some rights, and then that will start infringing on the protected freedoms and rights of natural humans. So we'd have to block against that, and that's hard to do. So AI personhood, I'm going to argue, not a cure-all, or at least if we go down that route, we've got to be really careful about how we do it. All right, so these are the themes. With that as background, let's start talking about some examples. So what kind of challenges does AI create for the legal system? First of all, let's just look at a simple case where artificial intelligence causes physical harm. So simplest example is self-driving cars hit and kill a pedestrian. Do you guys remember a year or a year and a half ago, there was Uber in Arizona test driving its automated car system, its automated driving system. It was dark out. A pedestrian walked out onto the street. The car didn't react in time. During the test, the car hit and killed the pedestrian. Who is responsible and in what way? Right? We'll talk about some of the options. Notice that that self-driving cars is not the only context in which physical harm could be caused by an AI system. So consider an automated weapon system, for example, that might be deployed in the near future, not now probably, but to protect like an airport runway. Do you guys remember there was this case where somebody flew a drone over the Gatwick airport runway and it wreaked havoc for 2 days? So my thought at the time was, oh, we should get some of these swarms of drones to sort of operate a sort of defensive shield and shoot down anything that sort of comes into the flight path. Science fiction, obviously, but that would obviously solve the problem, right? Well, maybe it's risky, maybe there's some risk. So suppose you have a system like that and it starts behaving erratically and unforeseeably lands in the parking lot and sort of smacks into people's heads and injures them, gives them concussions and so on and so forth. Suppose it's a private company that's deploying this thing. Would they be responsible? Who and how and for what? So those are two examples in which AI could, in theory, cause physical harm. Let's look at the legal analysis of those kinds of examples. I'm going to focus on the Uber example just because it's more related to what we see here and now. It's less science fiction. OK, so the most obvious answer, maybe Uber, the company that was testing the self-driving car, is criminally responsible for something like corporate manslaughter. So in the UK, companies, if they, through carelessness in testing or in operating their systems, cause the death of a human, of a natural person, they can be guilty of corporate manslaughter. And there are some prosecutions, it's not super common, but there have been prosecutions, convictions for this offense. Basically, the requirement is that you'd have to show that Uber was grossly unreasonable in its testing protocols in this case, in order to convict Uber of corporate manslaughter. So to do that, you'll have to show that they should have done something differently. It was a gross departure from what we normally expect companies of that type to, the precautions we expect them to take. It's got to be really, really bad. And it also has to be, under the UK law, it has to be identified with senior management. So it's not enough that just some guy sort of who's out there following instructions made the mistake, but under UK law, it has to be attached to senior management. That's not the case in the US context, interestingly, so jurisdictions are different. But whatever, that means that it's a difficult challenge, in the UK at least, to convict Uber of corporate manslaughter. You'll have to come up with, first, an unreasonable behavior by the company, something they should have done differently, and you'll have to argue to a jury that it was really serious, and also that senior management knew what was going on. So, could happen, but it's pretty unlikely. In fact, I think the real challenge is going to be around proving that taking precautions would have made a difference and avoided the collision. That causation question is a big one. So criminal law is going to be challenging, but maybe tort law is a better fit for these kinds of problems. So you guys are generally familiar with the criminal-tort distinction, right? Criminal law means you're convicted of an offense, possibly go to jail, or at least pay a fine. Tort law is just about imposing a duty of compensation. So you've got to compensate someone for their injuries. So you're not convicted as or branded a criminal, but you may have to pay. So tort liability is easier to prove in a lot of ways. And in this case, you might try to argue, the victims might sue Uber, right? So the family of the dead person might bring a lawsuit against Uber, alleging negligence, alleging essentially that Uber wasn't sufficiently careful. And the standard is lower for a tort action than for a criminal case. So you don't have to prove a gross unreasonable breach of duty. All you have to do is show some unreasonable behaviors. It's a little bit easier. So that might be more likely. You might similarly bring a lawsuit if you're the family of the victim. You might bring a lawsuit against the programmers and say they were negligent for not foreseeing possible risks. Okay. Oh, and one other, before we get to the problem, one other theory is what's called products liability. So basically, it's a sort of area of consumer protection law. You have to show, to get compensation, you have to show that the product was defective. Either that there was a manufacturing defect, or that there was a defect in the design, so that it was not reasonably safe as a product. So you could try any of those three tort theories to get compensation. Here's the problem, and this gets back to the first theme on that slide. So it's hard to know if there was a defect, right? It's hard to know if the product, in this case the self-driving car, was reasonably safe or not. And in part the challenge there is that we don't know exactly what was happening within the algorithm, what factors it was paying attention to, whether it was sort of perceiving and behaving in a way that is defective, or whether it was just doing exactly as sort of it was meant to do and there's no design flaw. Challenge number 2, which I actually forgot to put on the slide here, but I will do so before circulating these, is the causation problem. So if the system was behaving autonomously, then you can imagine Uber raising the defense of, as Bonnie put it, it was my algorithm what did it, gov, right? It was the self-driving car, the autonomous system. That was the real cause of the accident. The system, although properly designed with every reasonable precaution, every reasonable foresight, nonetheless went on to do things that caused this harm, but it was a pure accident. The system is at fault. It's not my fault. I was as reasonable as I possibly could have been. You can absolutely envision that kind of defense being mounted by Uber's quite well-paid defense attorneys. So those are two challenges, the causation problem and then the what is a defect problem. So there's going to be an uphill battle in this case in imposing accountability for the Uber accident. All right, let's go on to a second case. I'm running out of time here. I'm going to speed up slightly. AI systems often employed to diagnose illnesses in a medical context. Suppose you have a system that looks at x-rays and other test results to detect whether the patient has cancer. Ryan knows these statistics as well and can rattle them off better than I can. But some of these systems are approaching a level of accuracy that far exceeds what human doctors can attain. So suppose we've got one of those kinds of systems that's more reliable than a human doctor. Nonetheless, there are a few cases where it gets it wrong. And so suppose that there's a false negative in this case. The algorithm says you're all clear, no cancer, but in fact the guy has cancer and he dies. But it was preventable, right? He could have survived if somebody had picked it up in time. So he dies and his family sues the hospital for medical malpractice, for negligence. Okay, that's going to be the primary response here, medical malpractice. You have to show that the use of the system was negligent, either that the system was defective or that its use in some way was defective. You can get the hospital to pay under those circumstances if you succeed. So here's the problem, right? Suppose we're in a world where the system is actually more reliable, more accurate than human doctors would have been. Where's the negligence? How is it unreasonable for the hospital to use that system? It's an improvement. It saves more lives. Of course, sometimes there'll be a risk of getting it wrong. It's not infallible. It's not perfect. And maybe this is just one of the unlucky ones, right? So the hospital and the doctors here will push back and say, no, we didn't do anything unreasonable. The system is actually better than human doctors would have been. There's no negligence. So that's going to be a real challenge to recovering compensation in this case. And a similar problem with products liability, with saying this is a defective system. Well, where's the defect if it's better than humans were? That's the challenge. So what kind of solutions might you offer here in response? Maybe you think somebody should pay in that incident where essentially somebody was killed in a preventable way by failing to detect the illness. One possibility is to just ratchet up the standard that's required for showing that a system is reasonably safe. So maybe it's not enough to be more reliable than human doctors. Maybe that shouldn't be an automatic defense. Maybe it should require a superhuman level of reliability. So it's got to be 99.9% accurate in order to avoid tort liability. Maybe, you might say. So I think that's, in general, a direction we will see the law going in. Ryan's written about this. But notice that it's not going to be that much help in this case, because we are sort of assuming in the way that the case was set up that there was no obvious malfunction, that this was inevitably an imperfect system, a system that's not perfectly infallible, will sometimes yield false negatives, and so you'll have some cases like this, even with a ratcheted up standard for negligence or product defects. Okay, a second kind of response you might imagine, well, let's punish the system itself, or not punish, but let's impose liability on the system itself, require AI personhood. That's a bad idea for all the reasons that I explained already. I won't go through that again. So these kinds of cases pose a challenge, if nothing else. Let's talk about two more cases. What about artificial intelligence used in a cyber attack? This is going to be one of my good news examples. So I think the law is pretty good shape for this one. So suppose that using using a machine learning algorithm, that you've got some hackers who automate a cyber attack process. Normally it would have been really time intensive if you just done it by hand or with sort of a good old fashioned AI approach, just sort of non-machine learning. But with machine learning, you can expand the reach and reach a larger number of individuals. Here's an example of what I have in mind. So spear phishing, where you try to phish people, get them to give up their personal information through individualized, so not just a mass email saying, hey, how's it going? And then somebody responds, but rather I find out things about you in particular, right? And then I phish you as an individual. So that's spear phishing. You can write an algorithm that uses individualized information of this kind at massive scale, right? AI enables that kind of application. And so target a whole institution. So go after all University of Surrey employees with individualized information, trying to trick them into releasing their personal information. Okay, what do you do in that kind of case? So thankfully, I think criminal law has a pretty direct response. You don't need to do very much for the law to respond to this kind of challenge. Existing laws straightforwardly cover this kind of misconduct. Just look at the kinds of crimes we have on the books already. You could charge the hackers with fraud. You could apply general computer crimes like unauthorized access, which is criminalized under the Computer Abuses Act in the US. Or you could just go for traditional privacy violations, or if they're monetary gains that are acquired, theft offenses. So the criminal law makes this kind of activity a crime already. Here's the problem. It's a practical one. Okay? It's catching the guys who did it, right? It's figuring out who's responsible for the cyber attack, figuring out where they are, sending in the police, the SWAT team, the helicopters, and apprehending them. That's going to be hard to do because it's a sort of cyber attack. So the issue is, I think there's a challenge here, but it's a challenge that's not special to AI. I think it's a challenge that is generally a feature of cybersecurity threats. Because of the remote nature of those kinds of attacks, it's just hard to enforce. So there's a law enforcement challenge that AI introduces and maybe makes more extreme, but it's not different in kind than the kind of sort of enforcement challenge that we already see with cybercrime generally. So I don't think you need massive changes in the law to address this spear phishing example. But there are a few wrinkles that I want to briefly talk about. What if these are just questions for you to consider. What if the hackers didn't program the algorithm itself, but they just sort of purchased it on the dark web? Would the programmers that they purchased it from be liable? Especially if they know that it was not intended, if it had no other legitimate use than like cyber attacks, right? Probably that would make the programmers liable, but there's a question about how far that should extend. Suppose it was university researchers who were just trying to develop a new technique, and their research got out and then started to be sold or misappropriated and used on attacks of this kind. Would there then be legal liability? So all of you computer programmers in the room, be afraid, be very afraid. I think we should not go there. We should resist that, but it's a challenge. You see some discussion on this. Maybe more interestingly, well, at least more kind of eye-catchingly, what if the program was intended for benign purposes, like liaising with students, getting information about what they want for their studies, their supplies, and so on, but then it goes rogue, right? You see these sort of horror stories about AI going rogue. Probably not something we need to worry about in the near future. It's a science fiction possibility, but it's legally interesting to think about. So suppose the algorithm goes rogue and initiates of its own accord a cyber attack, right? What do you do? The challenge is that it will be difficult to impose legal liability because the system behaves in a not foreseeable way. So that suggests that the users and the programmers, because they didn't foresee or anticipate the harm, they didn't do anything unreasonable. And even if they, or they didn't do anything unreasonable, and they can't really be said to be the cause of the harm. The reason is unforeseeability breaks the chain of responsibility and sort of cuts things off for liability purposes. This is the causation challenge that I started out with. As soon as you have an algorithm behaving in unforeseeable ways, that creates a roadblock for imposing liability through the law, given existing causation principles. So maybe one solution is this at the bottom. Maybe what we need to do for now sort of abstracting from the cyber attack context, in general, to block against unforeseen behaviors that algorithms might engender, you should require, the government might require, extensive testing in the wild, as they say, right? Real life testing requirements to sort of extract or uncover these kinds of unforeseen, or at least ex ante unforeseeable behaviors. If you say, look, we did extensive testing in the wild and it seemed entirely safe, and then it goes off into commercial use and causes harm, then the company or the programmers who developed the system could say, we tested it extensively, we had every reason to believe that it was safe, so don't hold us accountable. It really was a pure accident. I think that's one possible solution to explore. Requiring training requirements as a way for companies and programmers to create a reasonableness defense in response to liability lawsuits. Okay, last example, and then I'm going to wrap up. I'm almost out of time. You saw this graph already. Bonnie talked about the flash crash, right? Suppose you've got these two trading algorithms that are trained to recognize patterns in sort of buying and selling behavior, and it buys and sells when certain conditions are met. So you see this kind of volatility, and you see this price level, and this volume of transactions, and so on, and it says, that's a sign that things are about to go down, so sell, sell, sell. And then you have another algorithm that picks up on that, and it recognizes conditions in which it's programmed to sell, 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 and there's a reinforcing feedback loop, and all of a sudden you have something like the flash crash. That's sort of the story that Bonnie explained in more articulate and detailed ways than, bless you, than I was able to. So what if this was an unforeseeable, and in fact, I think in the real case in 2010, this was an unforeseeable kind of event, that these two algorithms would interact in this way, or maybe it was more than two, the set of algorithms would interact in this way to produce this massively harmful and expensive sort of market response. Suppose that lots of people are harmed. Suppose there's a class action lawsuit brought against the hedge funds or the banks that employed the algorithms to try to recoup some of their losses. Would that work? I mean, in reality, probably not. So criminal liability is going to be difficult. You're generally to get criminal liability in the context of securities regulation, you are going to need intention to do harm, intention to defraud, or at least knowledge that you are defrauding. If not that, then at least awareness of a risk that this might happen. But remember, we're assuming that this was unforeseeable. Nobody could have reasonably foreseen this would happen. So criminal law is not going to get any purchase on the problem. You might try tort law. You might try a liability suit, right? A sort of private lawsuit to get compensation for your losses on something like a negligence theory. Maybe you would say the banks, the hedge funds, they were negligent in using the system, right? Because they should have been more careful. But again, at least looking at the facts, where assuming this was an unforeseeable kind of problem, nobody would have been negligent. Maybe after the flash crash and this starts to become a salient threat, then you realize, aha, there's a risk. And so then you can start to be charged with the responsibility to take some precautions. But the first time this unforeseeable feedback loop happens and the massive sort of crash occurs, no one could have foreseen the risk, we're assuming, and so nobody was negligent. So there's a problem there. So this looks like it might be one of the cases in which there's just an accident. So that's the first conclusion here. Maybe, and this is a question for you guys to consider, is this just an accident for which nobody is sort of morally or legally responsible? Second conclusion, this might be the kind of case where you'd be tempted to trot out AI personhood. Let's hold the algorithms responsible directly. If the hedge funds and the banks and the programmers were not negligent, we'll punish or hold the AI itself responsible. That's impractical. It's conceptually pretty dicey for reasons I explained. And again, it's not obvious that there was any actual defect in the way it was programmed. This was just an unforeseen side effect of the normal course, the normal behavior that the system was intended to have. Last suggestion, which I want to run up the flagpole for you, strict liability. Do you guys know what this means? So imposing liability even when nobody was at fault, even when there's no direct sort of thing you can point to, a precaution you can point to that some human or some company should have taken. That's called strict liability. And we see this in some areas with hyper or ultra hazardous activities, like hauling nuclear waste, for example. So sometimes in the US context, for example, you haul nuclear waste on the highways and an accident happens and the nuclear waste spills and causes harm. Even if the company doing the long haul, the sort of trucking company, was entirely reasonable, took every possible precaution, because this is sort of carved out as an ultra hazardous activity, the company can be held strictly liable. In other words, might have to pay even if it was not unreasonable. The flash crash looks like the kind of activity that you could start to describe as ultra hazardous. Maybe strict liability would be a legal response to that kind of behavior or to that kind of problem. Notice, however, that this might be bad for other reasons. It's a possible move. It's pretty legally straightforward to impose strict liability if the government passes laws supporting it. But look, it ends up penalizing people who we agree were not actually at fault in any way. They didn't do anything wrong. They took every possible precaution. So isn't it kind of unfair to make them pay? Why not just look at this as an accident? So I think that's at least a challenge that you would have to look at and address before rushing to pass strict liability laws. Generally, in the law, we don't want to impose penalties on people unless they were at fault in some way or responsible in some way. So that's a challenge for strict liability. Some people like it. I'm a little more skeptical. But it's a debate. OK, just wrapping up. Big problem is foreseeability and causation. AI personhood is not obviously the answer. 3, strict liability looks like a practically implementable fix that the law could reach for, but it's problematic. It could be overly burdensome on businesses that are developing socially valuable products and systems. But maybe you could say, hey, we've got to do this in order to create public trust in AI systems, so there might be some balancing there. That's above my pay grade. That's a matter for Parliament to decide with input from researchers. So watch the space. But that's at least a debate to be had. One last solution for you to consider: what about insurance requirements? If you have a construction company that goes to build a building, right, and they have these tall cranes, in order for the cranes to be permitted, the crane operators to be permitted to use that potentially dangerous technology, they've got to have insurance, right? It's been known that cranes, despite the best possible precautions one can take, could still tip over. A couple years ago, there was a big crane collapse in New York City that ended up killing a few people. The crane operators have to have insurance as a condition of being allowed to legally operate. So maybe some kind of insurance requirement would be advisable to impose on operators of certain categories of AI systems, particularly those that have the capacity to cause massive havoc, systemic harm, if they operate in unforeseeable ways. So maybe insurance is an additional kind of solution here that the law could require as a condition of operating. And this can be implemented in different ways, but that's another idea for you to consider as a possible solution. The 2 solutions to take away from this talk: strict liability, question mark, and insurance, question mark. So that's it for me. That's all I'm going to say. I'm going to pass it over to Ryan. I went slightly over. My apologies.